Good afternoon, and welcome to this Center for Brooklyn History talk on the fight for fair and impartial courts. My name is Marcia Eli. I am the Director of Programs at the Center for Brooklyn History, which is a part of the Brooklyn Public Library. We are truly honored to be partnering today with three distinguished organizations to bring you a two-part program. First, a brief, neutral presentation summarizing the role of the judiciary in our democracy, created and presented by the American College of Trial Lawyers and the National Association of Women Judges. And second, a discussion co-presented with the Brennan Center for Justice that pulls back the curtain and burrows in a bit, uncovering concerning threats to our judicial system, what's at stake, and why we should care. Before I tell you about our partners and introduce our guests for part one, I want to share a housekeeping matter. There is closed captioning available at the bottom of your screen. Just activate it by clicking that function on the Zoom screen. And I also would be remiss if I didn't encourage you to explore future Center for Brooklyn History talks. In the next few weeks, for instance, we'll be looking at the death penalty with Mark Bookman, who just wrote a book about it, Philadelphia DA Larry Krasner, the appeals Josie Duffy Rice, and the Innocence Project's Christina Swarns. And later we'll be welcoming a panel of experts and historians to explore the facts and cover up of the Tulsa Race Massacre in connection with the 100th anniversary of that horrific event. Those are just two of many programs we have coming down the pike, and I really hope you'll consider joining us for these and future free events. Now it's my honor to set up part one of this program. The presentation you're about to see is thanks to two organizations doing incredibly important work to support the role of the judiciary in our democracy. They are the National Association of Women Judges, which is dedicated to promoting the judicial role of protecting the rights of individuals under the rule of law through diverse judicial leadership, fairness and equality in the courts, and equal access to justice. And the American College of Trial Lawyers, recognized as the preeminent organization of trial lawyers in North America and dedicated to maintaining and improving the standards of trial practice, professionalism, ethics, and the administration of justice. The Judicial Independence Committee of the ACTL has succeeded in making the ACTL a strong, nonpartisan advocate for the importance of fair and impartial courts, and particularly in the face of recent threats to judicial independence. Our presenters this afternoon are both fellows of the ACTL, and I am delighted to tell you who they are and turn it over to them. I'll be back after their presentation to introduce part two. Matthew Fishbein most recently served in the Brooklyn DA's office as Executive Assistant District Attorney for the Investigations Division. As a litigation partner at Debevoise and Plimpton through 2018, he specialized in white-collar criminal defense, internal investigations, and complex commercial litigation. He previously held leadership positions in two United States Attorney's offices as Chief Assistant United States Attorney in both the Southern District of New York and the Eastern District of New York. Judge Ann Donnelly was appointed United States District Judge for the Eastern District of New York by President Barack Obama in 2015. Prior to her appointment to the federal bench, Judge Donnelly was a judge of the New York Court of Claims and presided over criminal matters in New York Supreme Court in Bronx, Kings, and New York counties. Judge Donnelly spent 25 years in the New York County District Attorney's Office, where she served as an appellate lawyer, senior trial counsel, and chief of the Family Violence Child Abuse Bureau. Welcome, Matt. Welcome, Ann. I turn it over to you. You're muted, Matt.
Okay, already getting off with a glitch, but thank you very much, Marcia, and thank you to the Brooklyn Public Library Center for Brooklyn History for hosting this event. And welcome to our audience, which I understand includes people from all parts of the country, not just Brooklyn. And that is particularly appropriate because our topic this afternoon is one of national concern, the threat to the independence of the judiciary. What I'd like to do is to start with an example of this threat. In February of 2019, the Alaska Supreme Court issued a decision holding that a state statute which narrowed a woman's eligibility to receive Medicare funding for abortion was unconstitutional. The court found that it violated the Equal Protection Clause of the state constitution because it imposed more onerous Medicare eligibility requirements on women who were seeking abortion than women who sought to carry a pregnancy to term. As you might imagine, this was a controversial decision. It was hailed by some and reviled by others. One of the people who hated the decision was the governor of Alaska. But as governor, he did not have the power to undo the court's decision. Governors cannot reverse decisions of the judicial branch. But instead, he found a way to retaliate against the court. Several months later, in June of 2019, the governor vetoed salary increases for Alaska appellate judges, including the judges on the Supreme Court, which had previously been passed by the state legislature. And he also issued a veto which had the effect of reducing the appellate court's budget by $300,000. Now, the governor made crystal clear that these vetoes were explicitly tied to the court's decision. He explained, and I'm quoting, "The legislative and executive branches are opposed to state-funded elective abortions. The only branch of government that insists on state-funded elective abortions is the Supreme Court." And so, he explained, he was reducing the court's budget by the annual cost of elective abortions. Now, regardless of whether one believes that the Alaska court's decision was correctly decided, the Alaska governor's actions raised severe concerns because they challenged the very underpinnings of our constitutional government, that the courts are the final arbiters of the law, final arbiters of what the Constitution means, and should be insulated from political considerations and retribution. Regrettably, as you'll soon see, the Alaska veto did not stand alone. It's just one example of a growing trend in many states across the country that challenge the independence of the courts and their role in our system of government.
Our program today is going to focus on the importance of fair and impartial courts to the rule of law. And we're going to examine some of the recent challenges to maintain that status. That's going to happen in the second portion. As Marcia said, Matt and I are going to present a short refresher that the American College of Trial Lawyers and the National Association of Women Judges put together on the role that the courts play in our constitutional system and how that role is different from the roles of the other branches of government. It's a nonpartisan refresher that is intended to be a good lead-in to the panel discussion that's going to follow. So I mentioned the rule of law. John Adams defined a republic as a government of laws, not men. Today, we would say a government of laws, not people. And what that means in simple terms is that no one is above the law, regardless of that person's position in the government or society, or regardless of how powerful that person might be. That includes members of Congress, the president, and judges. It also means that the government itself must obey the law. Congress cannot pass legislation that exceeds its power under the Constitution. The president and members of the executive branch cannot take actions that exceed the powers that are given to them. So the principal role of the courts in our system is to follow and enforce the rule of law regardless of any political consequences.
So Judge Donnelly and I are going to focus on 4 topics. The first is we will examine the unique role of the judicial branch in our constitutional design. We'll distinguish between what judges do and what other government officials do. We'll evaluate the significance of the judicial branch and the need for fair and impartial courts. And then we will explore some of the recent challenges that are facing the courts. Next slide, please. What does the, hold on, I think yeah. So let's start with the branches of government. As we probably all learned in civics classes back in high school or middle school, there are 3 branches of government in both the federal system and also in each of the 50 states. There's the legislative branch, which in the federal system is Congress, and in the states, the state legislature. They're responsible for enacting the laws. Then there's the executive branch, the president or the governor if it's a state, which is tasked with executing the laws, enforcing the laws through cabinet agencies and administrative agencies. And finally, the judicial branch consisting of trial courts and appellate courts, whose job is to adjudicate the law in cases that come before the courts. So let's first look at what the judicial branch does. Judge Donnelly, as Marcia said during the introduction, you were in somewhat of a unique position, having served both as a state court judge and now as a federal judge. Why don't you start by telling us what exactly do judges do? Well,
in really simple terms, judges resolve disputes between parties, whether that's on the civil side or on the criminal side. Obviously, a court can only act when a case is brought before the court. A judge can't reach out on her own and decide that she's going to interpret a law or rule on its constitutionality. So when a case does come before the court, the role of the judge is to apply the law to the facts of the case and then explain how it is that the law does apply to those facts. Sometimes that case is going to involve reviewing a law that the legislature has enacted to determine whether the law is constitutional. Sometimes it might review an executive branch action to determine whether the governor or the president has exceeded her powers under the Constitution. But most cases, it simply means applying the law to the facts and circumstances of everyday disputes that come before the court, either, as I said, as a civil lawsuit or a criminal matter.
So, Judge, talk a little bit about how judges make decisions.
Well, judges make decisions based on the law and on the facts of the case. A judge has to be fair and impartial and interpret the law regardless of any personal opinion the judge may have. And the judge has to apply the law as it exists to the facts in the case before the judge. And in addition to not being influenced by any personal feelings, the judge can't be influenced by any views of other people or by political consequences of a decision.
So what does it mean to follow the law? How does a judge determine what the law is that applies to a particular set of facts and circumstances?
Well, depending on the case, the judge is going to use different sources to determine what the law is. We don't start with a blank slate. So we'll look to the Constitution, the US Constitution or the state constitution. We'll look to statutes that have been enacted by the legislature and also to prior judicial decisions. All judges, at least in the district court and in the mid-level courts, are bound by what's called stare decisis, which means that we must follow decisions of superior courts that have been decided in similar cases. So as a district judge, I'm obligated to follow the Second Circuit Court of Appeals and the Supreme Court of the United States. Sometimes there's no guidance from the Second Circuit, and a judge may look to decisions in other circuits to make a decision.
Thank you. You referred to the fact that sources of law could include state statutes, federal statutes, the Constitution. In determining the governing law, judges must sometimes analyze competing sources of law, sometimes which are in conflict. As you can see from this chart, there's sort of a level of law. The federal law and the US Constitution take a priority over state law. And this is because of the supremacy clause in the US Constitution, which says that federal law is supreme. The US Constitution, of course, is the highest authority, and that takes precedence over federal statutes, state statutes, and decisions from lower courts.
So in our federal system of government, we have both a federal court system and a state court system. Each one of the states has its own state court system. And it sometimes seems like federal courts get a lot of the attention, but the fact is that about 90% of all cases are heard in state courts.
Thank you. So you've probably touched on this somewhat in your prior explanations, but how is the judicial branch different from the other branches of government?
Well, aside from the different functions that you discussed earlier, the principal difference is that the judiciary is not a political entity. The legislative and executive branches are political entities, and courts are meant to be insulated from politics. And that's true even if judges are elected to their positions.
So the legislative and the executive branches are, of course, not insulated from politics. They're designed to be responsive to the will of the people. And as a result, it's to be expected and perfectly appropriate for legislators, governors, the president to listen to and be responsive to public opinion, to lobbyists, to all sorts of political pressures.
The judicial branch, as I said before, was designed not to be a political or representative branch. So a judge can't be influenced by public opinion, by political pressure, or by special interests. As I explained before, the judge is duty bound to follow what the law is, regardless of any of those outside pressures. When a judge acts in accordance with her constitutionally assigned role to interpret and apply the law, the court honors the fundamental democratic principles that laws are to be enacted by the representatives of the people, and that the separation of powers has to be maintained by the branches of government. Now, there are times and in our history when the law is expanded. And I think so judges are making new law. And I think one of the most recent examples of that, although they exist all throughout our history, are the marriage equality cases. Those are a good example of a time where the laws have changed.
Okay, next slide, please. In following the law, judges often make difficult decisions that may not be popular. This applies not only in cases of constitutional dimension, but in many day-to-day decisions. Here's an example. Think of a lawsuit challenging the construction of a housing development in an environmentally protected area. Let's say one which is populated by migrating birds. In deciding whether or not the law prohibits or permits the construction of the housing, the judge cannot consider such factors as whether there's a pressing need for housing. The judge can't consider if he or she has a personal interest in the environment or in migrating birds. The judge should not consider that there's a 90% approval rating of the housing project or an opposition to the housing project.
The unique role of the judiciary is best illustrated in the protection of minority rights. The Constitution and other laws recognize that certain rights take precedence even in the face of majority rule. For example, the First Amendment freedoms of speech, religion, press, and assembly are examples of that. So even if 99% of the population were to oppose the right of white supremacists to demonstrate peacefully in Prospect Park, courts have the responsibility to protect the First Amendment rights of those groups to do so, regardless of their popularity. The courts serve as a bulwark that protects the rights of minorities, even in the face of overwhelming popular opposition.
Now, as we have seen, that's the ideal. The ideal is that judges should be insulated from politics. But what is the reality? Is it even possible for them to be such insulated? We've all seen the emphasis in recent years by both political parties on the selection of judges and the focus on certain hot button issues and how those judges are likely to decide them. Issues such as reproductive rights, voting rights, religious freedom, among many others. Those issues and how prospective judges are likely to rule on them certainly seem to be on the minds of the senators who are charged with voting on their nominations. Now, prospective judges are not permitted by ethical rules to prejudge matters. And we've all seen congressional hearings where senators are extremely frustrated because they can't get the nominee to give a definitive answer on how they would rule on a particular hot button issue. But that being said, it would be naive to suppose that politics do not enter the decision of who gets nominated and confirmed. What about after the judge is on the bench? Judge Donnelly is someone who has served on both the state and federal bench. How often, if at all, do politics or public opinion enter into your decision-making or the decision-making of your colleagues?
Well, the fact is that 99% of the cases that come before most judges, and that's certainly true in the district court, have no political dimension at all and no public interest beyond the parties that appear before the judge. But in the few cases that might have a broader interest or involve controversial issues, which does happen from time to time, my experience is that judges do their level best to keep those factors out of their decision-making. And I can only point to my own court as an example of the Eastern District of New York. In our court, we have judges that were appointed by every president imaginable, going back and it has been my experience on that court that every judge to a person who appointed him or her is studious and follows his or her duty to apply the law to the facts of the case, regardless of what the political consequences are.
Now, federal judges, as you are today, are nominated by the president and have life tenure after they're confirmed by the Senate. And the only way they can be removed is by impeachment for high crimes and misdemeanors, which I think has happened just a handful of times in the history of the country. The argument for life tenure is that it helps insulate judges from public pressure and political influence once they sit on the bench. And we've all seen instances where Supreme Court justices have voted in ways that surprise people, that seem contrary to what everyone presupposed were their political leanings. But let's talk a moment about state courts, where you've said that 90% of all cases are heard. How are state court judges selected, and what type of tenure do they tend to have?
So across the country, I mean, there are the state court methods of judicial selection really run the gamut from partisan elections where the candidates are supported by political parties. There are also nonpartisan elections, gubernatorial appointments, legislative appointments, And then there are some hybrid methods. But unlike the federal judiciary, in the state court, there is no life tenure except for the 5 judges who sit on the Rhode Island Supreme Court. So the Brennan Center has prepared a slide that shows all of the ways that the highest courts in the different states are selected. And you can see by the different colors that, as I said, these selection processes they run the gamut. There are nonpartisan elections, there are merit selection, gubernatorial appointments, and various hybrids. In New York, judges reach the bench at various levels through different ways. Some are appointed by either the governor or, in the case of certain lower courts, by the mayor. There are partisan elections for judges. And in the case of the New York Court of Appeals, which is our highest court, there is a hybrid system where a nonpartisan committee submits up to 7 names to the governor, who then has to choose someone to nominate, and then that person has to be confirmed by the state senate.
So even where judges are elected and endorsed by political parties, the ideal is that they are different from candidates running for legislative or executive offices. For instance, as I think I mentioned earlier, they're prohibited by ethical rules from saying how they will decide on various issues once they ascend the bench. So they can't campaign promising to rule a certain way on a certain issue. This statement from Chief Justice Roberts reflects how it's supposed to be. Chief Justice said, "Judges are not politicians, even when they come to the bench by way of the ballot. And a state's decision to elect its judiciary does not compel it to treat judicial candidates like campaigners for public office. The state may assure its people that judges will apply the law without fear or favor." Now, as I said, that's the ideal, and I expect one of the topics that the panel is going to cover following our presentation here is whether, in fact, it works out that way. Go to the next slide. In addition to concerns regarding the politicalization of the judicial selection process, another threat to the independence of courts in recent years has come from state legislatures. Take a look at this map, another graphic prepared by the Brennan Center. The yellow color indicates states that have attempted to limit the court's role or independence in one way or another. These attempts include interjecting greater politics into the selection process. One recent example is the state of Indiana, which presently has a nonpartisan selection process. There's a legislative initiative now to change that in favor of partisan elections where the judicial candidates would be supported by a political party. Some legislatures have taken actions to try to remove judges in response to unpopular decisions, such as having recall procedures. There have been efforts to punitively reduce judicial compensation, as we saw in the Alaska example. There have been initiatives to shorten judicial terms. And there have also been some states who have attempted to enact laws to prohibit state and local officials from enforcing federal court orders. One example of that is Judge Donnelly mentioned the recent Supreme Court marriage equality issue. Some state legislatures proposed legislation which would have prohibited state officials from registering same-sex couples who were looking to get married. You'll hear more about these developments from our friends at the Brennan Center in a few minutes.
The trends that Matt mentioned have raised concerns from people regardless of their political persuasion. Retired Justice Sandra Day O'Connor had this to say about it. "I am anxious about the state of the judiciary in America. What worries me is the manner in which politically motivated interest groups are attempting to interfere with justice."
Those words from Justice O'Connor conclude our part of the program. In the panel that's following, you'll hear a discussion in greater detail of some of the more troubling threats to the rule of law and the efforts to confront them. So on behalf of Judge Donnelly and the American College of Trial Lawyers and the National Association of Women Judges, we hope that this refresher has served to set the stage for that discussion. Thank you.
Thank you. Thank you so much, Matt and Ann. It's really so interesting to be reminded of the things that we've learned, but we forget. And that was fascinating and interesting and full of great information. Now we pivot to a conversation that centers this civics lesson in the here and now, with 4 eminent panelists, all working on the ground as activists and advocates for fair and impartial courts. And I am truly, truly grateful to the Brennan Center for Justice, and in particular their Democracy Program and Fair Courts Project, for bringing these panelists together. As they engage in conversation, I also want to invite all of you listening to join by typing your questions in the Q&A. And now I will briefly introduce our panel, and it's going to be brief. And I could speak at length about all of these folks because they're all incredibly distinguished. But in the interest of getting to it, forgive me for abbreviating. Patrick Berry, we'll start with, is a fellow and counsel in the Brennan Center's Democracy Program, where he focuses on voting rights restoration and promoting fair, diverse, and impartial courts. He received his BA from the University of Central Florida and his JD from the University of Pennsylvania Law School, where he was an executive editor for the Journal of Law and Public Affairs. Welcome. Kathryn Personette is Deputy Director of Campaigns at the Pennsylvania Budget and Policy Center. Recently, she has been in the eye of the storm, fighting on the ground to keep PA's courts fair through a constitutional amendment and other activities to prevent judicial gerrymandering, which you will hear more about. Welcome, Kathryn. Welcome, Katie. Eric Lesh is Executive Director of the LGBT Bar Association and Foundation of Greater New York. And Eric previously served as Lambda Legal's Fair Courts Project Director, where he focused on eliminating bias in the legal system, increasing diversity of the judicial bench, and expanding access to justice for LGBT people and those with HIV. He is widely published, including a 2017 publication titled "Justice Out of Balance: How Judicial Elections and a Stunning Lack of Diversity on State Courts Threatens LGBT Rights," which was featured by Adam Liptak in the New York Times. And last, but by no means least, is Alicia Bannon. Alicia is the Managing Director of the Brennan Center's Democracy Program, and she will be moderating this conversation. She leads the Center's Fair Courts Project, directing research, advocacy, and litigation. She has authored several nationally recognized reports on judicial selection, access to justice, judicial diversity, and government dysfunction. And her writing has been featured in the New York Times, Atlantic, Time, many others. She clerked for Honorable Sonia Sotomayor in the United States Court of Appeals for the Second Circuit, and Honorable Kimba M. Woods in the United States District Court for the Southern District of New York. So welcome to Alicia, welcome to all of you. Thank you so much for being here. Take it away.
Thank you so much, Marcia, for that wonderful introduction, and to Judge Donnelly and Matt Fishbein for their really excellent presentation. And I am just delighted to have the chance to moderate this panel with Katie, Patrick, and Eric, each of whom has been involved in the ground in the fight for fair, impartial, and diverse courts. And so we're going to spend the next bit of time talking about the stakes, what's at issue here in the fight for fair courts, and what's actually been happening on the ground in individual states. I'm going to start us off by turning to Eric. And, Eric, I've worked on courts issues for a long time. I'm not going to lie. Sometimes it can seem like a sort of technical topic, not something that everybody sort of wakes up and, at breakfast time is thinking about, we need to care about the courts. So I was hoping that you could start us off by speaking a bit to what you see as the stakes here. Why should we care? Why is it important when we see threats to judicial independence, or when we see courts that aren't reflective of the diversity of the communities that they're supposed to be serving?
Really excited to be here and really excited to speak about this particular topic. A lot of us really engage around politics. We know who's running for our local offices for federal elections, but we have no idea who is serving us on the judiciary and how they got there. But they really judges decide every issue that is critical to our lives and to our justice system, to our democracy. From my personal experience, I'm a lawyer here in New York. It used to be up until 1973 when the New York Court of Appeals became the very first state court to rule that it wasn't constitutional to deny admission to the bar to LGBT people. It used to be that I could be disbarred or denied admission to practice law here. I work for the LGBT Bar Association of New York. We're 43 years old, but it used to be that you could be denied a charitable purpose as a tax-exempt organization if you worked for LGBT people. I got married here in New York State in 2012. And in 2006, our high court, with judges sitting up there, none of whom were LGBT, ruled that we didn't have the equal right to be married here in the state of New York. And of course, we've had decisions about LGBT families, children who have only known a non-biological, non-adoptive parent as their parent their entire life. Not until recently did our high court rule that you actually, as a non-biological, non-adoptive parent, have the right to even go into court and ask for custody or visitation. So whether we're talking about family issues, marriage equality, the right to participate in the profession, anything, voting rights, the environment, reproductive health, all of these issues come before courts, and judges are critical to how they're decided.
Thank you so much. Patrick, I'm going to turn to you to hear a bit from you about expanding on, in the previous presentation, we heard about legislative assaults on judicial independence. And I was hoping that you could tell us a little bit more about the trends that you're seeing this year, and how worried should we be right now about these state legislatures targeting the courts?
Sure. So first, thanks so much for having me. But in terms of the sorts of bills that we're seeing, in addition to the bills that were mentioned in the previous presentation, so again, those are bills that would change how judges are selected for partisan gain, bills that would interfere with judicial decision making, or put other types of pressures on courts to change the outcome of future cases. We've seen at least 3 new troubling trends this year. The first trend that we've seen are bills that are clearly being introduced in response to decisions related to last year's election. And some of these bills have actually been signed into law. In Georgia, for example, a state that is always in the news for hours-long lines at the polling places and other forms of voter suppression, a provision of the bill that was signed into law by Governor Kemp limits the ability of some courts to extend polling place hours. There are also bills in Kentucky and Kansas that have been signed into law that explicitly provide that only the legislature has authority to suspend or revise state election laws. And there are bills that would do the same in Arizona and Missouri. Additionally, bills in Texas, a state that saw plenty of election-related litigation, that would change the judges that hear election-related disputes, or even create a new non-judicial state elections tribunal to hear certain election-related cases. We've also seen two partisan attempts in Minnesota and Tennessee to remove sitting judges over decisions they issued last year expanding access to the ballot because of the pandemic. The second trend that we've seen this year are bills that would gerrymander courts. In Montana, for example, the legislature just last week voted to put a proposal on the ballot in 2022 that would require the state Supreme Court justices to be elected by district as opposed to statewide. And while there can certainly be benefits to districted elections, there are circumstances around this bill and many others that we've seen that actually suggest it's an attempt to reshape the state's courts, which are, in the case of Montana, the justices have been criticized as being too liberal. So for starters, the bill was introduced by a Republican lawmaker with ties to a conservative dark money group that has spent money in the past to influence the outcome of judicial elections in the state. The bill would also divide Montana into 7 districts, 5 of which would be likely to choose a Republican candidate. Another bill in Texas would gerrymander the state's 14 intermediate appellate courts by cutting the number of courts in half. Democrats have won majorities on 7 of the 14 appellate courts since 2018, and the redrawn districts would result in 5 appellate courts with Republican majorities and 2 with Democratic majorities. The third trend that we've seen are bills that would create completely new courts to hear cases involving the constitutionality of state laws. A bill in Texas would create a new statewide appellate court made up of 5 judges elected statewide to hear certain cases involving the legislature or the governor. Currently, those cases are heard by the Third Court of Appeals, which is comprised of a majority of Democratic judges, and no Democrats have won statewide office in Texas since 1994, and all of the justices on the state's 2 highest courts are Republicans. Another bill in Tennessee would create a statewide trial court to hear cases involving the legislature rather than the judges in the state's capital, Davidson County, where Republican lawmakers have criticized the judges as, again, being too liberal. And unfortunately, there is plenty reason to be concerned. While we've seen symbols like these before in the past, we are seeing way more bills this session, and more of these bills are actually becoming law. In previous years, no more than 1 or 2 bills will go into effect, whereas this year, so far, there are at least 8 that have been signed into law. And we expect these attacks to continue and possibly even get worse, given the rightward shift of the federal judiciary, which means state courts will become more important in the coming year, and increase in attention can mean attacks. And we saw this certainly with last year's election, with many pro-voter lawsuits seeking to protect voting rights during the pandemic being filed in state court as opposed to federal courts. And we anticipate that we'll see it over the coming year, with many state courts being expected to play an important role in terms of redistricting, given the Supreme Court's decision that federal courts can't intervene in redistricting matters.
Thank you so much for that summary, Patrick. And I think, something that's particularly chilling to me is seeing courts being targeted so specifically for their role in election cases. I think that's something new. I don't think that's something that we've really seen in past years. And I think, the courts, and particularly state courts, were so critical in so many places in, ensuring the right to vote. And so I do see that as a really troubling trend. I'm going to pull Katie into this conversation now, and to hear more about her work in Pennsylvania. Pennsylvania has been on the front lines in a lot of this. And Katie, can you tell us a bit about exactly what has been happening in Pennsylvania, both how the judiciary is being targeted and how you and others in the state are pushing back?
Yeah, absolutely. Thank you so much for having me. It's perfect that I'm piggybacking on Patrick, because it is something that's happening currently in Pennsylvania. Back in 2018, a proposed constitutional amendment was introduced by a Republican House Representative Russ Diamond, then known as House Bill 196, and it would change how we elect our appellate court judges. And so our appellate courts consist of the Commonwealth Court, the Superior Court, and the State Supreme Court. And so we do elect them statewide now, but this proposed constitutional amendment would change that. It would change how we elect those judges on our appellate courts by electing them from districts that would be drawn by members of the General Assembly. And so this, obviously, we talked a little bit about it already, this would dilute the power of voters across the state, allowing legislators to favor their preferred candidates. This opens up our courts for partisan power grabs and harmful legislative influence. We heard a little bit about why this is a problem, but just to reiterate, we know that given the role that judges play in our constitutional government, district election is unnecessary, right? In Pennsylvania, we always talk about there's no specific county way to interpret our laws. I live in Montgomery County, and many of my friends live down in Philadelphia County, live all the way out in Erie County. There's no difference of interpreting the laws by county. And the amendment would undermine the independence of our courts, what we're talking about today. And so since this constitutional amendment, since this was a proposed constitutional amendment, what that means in Pennsylvania is that for it to become a law, it would have to pass out of the state House and Senate during 2 consecutive sessions, and then would be voted on by voters in a ballot referendum question in an election. And so we saw House Bill 196 pass out of the Pennsylvania House and Senate last session in 2020, and it reappeared as House Bill 38 this session in 2021, where in January, it did actually pass out of the State House Judiciary Committee by a really close vote. The vote was 13 yes to 12 no. And that's where it currently stands here for us. So it has not been brought up for a full vote out of the House or the Senate. And that has a lot to do, honestly, with the amount of work and the pressure that we've been putting on the state legislature for the last couple of months. And I'm extremely proud of that work. I'm going to use this to shout out to everybody that took action in the state. I'm extremely proud of the work that we did from our organization, the Pennsylvania Budget and Policy Center, including We the People Pennsylvania and Why Courts Matter Pennsylvania. We held several events and town halls, working with state legislators to educate constituents on these issues. And we engaged many activists through our platform to take action on this. We also created an amazing fight back table called the Judicial Independence Project of Pennsylvania, also known as JIPA, which again, I'm extremely proud and humbled to be a part of. It's a nonpartisan table of both grass tops and grassroots organizations. There's over 125 organizations that came together to fight back against judicial gerrymandering in House Bill 38. So that's just incredible. And we created this table to fight back for this one issue. We really built an amazing foundation to do so. We spent a lot of time holding educational events, seminars, conversations, town halls around judicial gerrymandering, and created several committees within the table that focuses on mobilization, outreach, lobbying, and litigation. For months, this table met every single week as the buzz and the buzz was up and things were moving with House Bill 38 this session. We engaged constituents all across Pennsylvania to take action by writing letters to the editor, writing letters and emails and making phone calls to their state legislators, and blasted this information on all social media platforms by using our social media toolkit that we created. So I really do believe that where we are right now is because of that work and that pressure from this incredible JIPA table, this fight back table, and all the work that had been done by constituents, community leaders, activists in Pennsylvania. Right now, we passed the deadline for it to be on the May primary ballot. So we felt pretty good about that small victory. That would have had to be passed, or excuse me, House Bill 38 would have had to have been passed by February 17th for it to be shown on the May 18th primary ballot. So we passed that deadline. It did not pass out of the House or Senate, but we do know that there is a chance for it to be passed for it to be on the November ballot. So we're in a weird holding period right now, but we are still doing events. We're still educating the constituents of Pennsylvania. We're still meeting monthly now with the JIPA table, providing, all of our activists who are a part of this table updates on where it stands. And to be honest, we built this incredible foundation and we're ready for if and when this does move forward in Pennsylvania.
That's so interesting. And it's inspiring to see, public education and this kind of work making a difference. Are there particular, what's moving the public? I mean, what are people responding to as you're pushing back against this measure?
Yeah, I mean, we did a lot of educational seminars on why the courts matter. So a lot of information, what Matt and Ann talked about earlier, a lot of people don't understand why our courts matter. So to even have a grasp on what judicial gerrymandering is or what House Bill 38 is, we really focused on what's important, why the courts matter. We kind of talked a little bit about and made the connection between the 2020 general election. Pennsylvania was a battleground state. We saw a lot of focus on our appellate courts during that time. So we kind of, we made the direction and we tied the knots to understand how people should care about the courts because of what happened over the recent months. And so I think people were fired up because of that. And we were able to engage right away and understand, hey, this is something this is what they're trying to do. I will say back in 2020, when it passed out of the House and Senate, it passed out of the Senate in 3 days with no public knowledge. There wasn't any hearings. The public didn't know about it. So I think because of the 2020 general election, because of the fact that Pennsylvania's appellate courts were such a hot topic for us and everybody's eyes were on our appellate courts during that time, it made our constituents and our public more interested on what's actually happening and why they should care.
That's great. So I guess I'm gonna turn back to Eric now. To the extent, I mean, we're on Zoom, so we're all over the place, but to the extent we're located anywhere, I guess right now we're located in Brooklyn. And so I wanted to talk a little bit about New York's courts. I know we heard a bit about that in the presentation, but can you tell us a little bit about, New York's court system, which I know is not the easiest to understand, and particularly what you see as some of the most significant challenges and needs here in New York?
No, I can't.
You got the short straw. You have to explain it.
All right. Well, for those of us who live and vote in New York and in New York City, you know that this is a mess. It's very hard to understand. Here in New York City, each of the 5 boroughs, we have the criminal and the civil court kind of system where judges are either appointed or elected. We have the state court system where we call the lowest level justice the Supreme Court, and those are Supreme Court justices, which makes no sense. Some of those the majority are elected. There's family court, there's surrogates court, there's the appellate division, which is the appellate courts of review. Those folks are appointed, but from the elected pool of Supreme Court justices. And then we mentioned a little bit the very highest court. There's a screening commission that looks at a couple of people, gives a list to the governor, and the governor has to pick from those people. So the path to the bench is hard to understand. It prevents a lot of people who might be judges from getting involved because it is a very political process. And it's very discouraging. And it also means that there's very little, if you're trying to encourage voters to understand and get involved, most of the time we go to the ballot and the primary happened and you're voting for judges who are uncontested by that point. It's confusing. Nobody understands it. It's been the subject of lawsuits, but it's not probably going anywhere anytime soon. And so the important thing to understand is how important it is that we fight for fair courts here in New York. And that involves everything from making sure that court rules are fair to people of all backgrounds, making sure that judges look like and represent the people that they're supposed to serve. The Brennan Center has done such a great job looking at high courts and this just galling lack of diversity on the courts that are supposed to understand and rule on issues that deeply affect us. Here for LGBT people, we have 340 high court justices across the US, and only 12 in the nation are LGBT. Here in New York, we just lost Judge Feinman on the Court of Appeals, who was the first openly gay person to serve. He unfortunately passed away. But again, it's all about feeling like your court system understands you, that you're going to be treated fairly. And when you survey populations about their feelings about the court system and whether they perceive it to be fair, by and large, if you're a minority, you've had terrible experiences in the courts, you don't trust them. So even the concept of preserving judicial independence is something that's foreign to a lot of people who feel like the courts are stacked against them already.
I think that's such an important point. And I guess building on that a bit, I'm going to turn to Patrick. What are the appropriate ways to criticize judges or to think about judicial accountability, kind of precisely to Eric's point that, courts don't always meet the aspirations of equal justice that we should all be aspiring to?
Sure. So, judges have just a tremendous amount of power. And so it's okay to disagree with or criticize their decisions, especially when they're poorly reasoned. But certain types of criticism, such as unsupported claims of bias, personal attacks, bullying, threat of impeachment, or even refusing to comply with a court's decision, those are sorts of criticisms that can undermine public legitimacy of the courts and also threaten judicial independence. Both of which are critically important in our system of government, and even more damaging are legislative attacks on the courts, like changing a court structure or taking away its authority over court rules or resources. Those are more damaging.
Thanks, Patrick. Katie, I'm going to turn to you now, and then I'll try to leave a little bit of time for audience questions because I know a number have come in, and we'll try to at least address a couple of them. Katie, could you preview for us the next several months in Pennsylvania? What exactly are you going to be watching for? What do you see as the biggest sort of threats and concerns with respect to the judiciary there?
Yeah, absolutely. So we always talk about how nothing is ever guaranteed in Harrisburg. And so we are ready and willing and able to go once House Bill 38 moves forward, if it moves forward. As I mentioned before, we saw it, then House Bill 196, move out of the Senate in 3 days without any public knowledge. There was no hearings. So we will not let that happen this time. We're watching our state legislature. We're watching the movement of this specific bill, and we're ready for it to move forward because we have this table set up already. We have that foundation. And we know that legislators did feel the pressure earlier, right? We're going to be watching for any sudden movement, although we have seen House Bill 38 move from on the table to off the table, back on, and so forth. That actually happened the previous session, and that's pretty procedural. But we do want to continue to watch that if it does continue to move. And so we are continuing to meet monthly on the JIPA table, our Judicial Independence Project of Pennsylvania. And so we're providing updates. The 125 plus organizations continue to meet again in this table. And we're ready with all of our resources, all of our links to continue that pressure. And as I said earlier, again, without really repeating myself, but it is important to know that we have not claimed victory yet, right? So I said, we passed the deadline for the May ballot. Our primary election is happening on the 18th, but we're not out of the woods because again, nothing is guaranteed in Harrisburg, and we are ready for if they do move it forward, if it is passed out of both the State House and Senate by August 2nd, it will be on our November ballot. And so we are not stopping the fight. We're continuing to hold events We're continuing to educate our constituents, keep the buzz up around this, provide our resources for this. And all of our resources on this, by the way, are on the Judicial Independence Project of Pennsylvania website. I believe that is in the chat there for you. We have a really amazing whiteboard explainer video on judicial gerrymandering that everybody loves to watch. It's only a couple minutes and it explains it in a really fun cartoon way. We have an action page set up. We got all the things you need, basically. And so because we're on this holding period, that doesn't mean that we're not stopping our efforts. We're just kind of waiting, but we're continuing to make sure our constituents and the people of Pennsylvania have the resources that they need to continue to educate their family, friends, neighbors, because so many people don't know about our judiciary system, especially our appellate courts in our state, and certainly people aren't aware what judicial gerrymandering is. So we continue to do that and educate our constituents.
Thank you. And so I'm going to turn to at least a couple of audience questions, although I apologize in advance because there's a lot. And so I don't think we're going to be able to get through all of them. The first question I'll pose to whoever on the panel wants to answer is about, I guess, federal appointments, federal nominations, and particularly how President Trump's imprint on the federal courts is likely to affect the judiciary.
I'd be happy to go. It's disastrous. Well, for folks that care about fair courts anyway. Most of the appointments by President Trump, he's appointed about a third of the federal judiciary, which is just astounding given that he was only in the president for 4 years. They confirm judges at a very rapid pace. These are folks that serve for life. Many of them were rated unqualified by the ABA. Lots of them are very young. Many of them have really strong right-wing, think tank experience that they bring with them. So a bias, a perspective to the bench. Lambda Legal, the LGBT organization, did a survey and found that about 1 in 3 Trump judges was openly hostile to LGBT rights, had openly stated so. So these folks are going to be a challenge. They're not going anywhere. But now, depending on your perspective, we have some real power to get progressives appointed, women. There haven't been very many people of color appointed under President Trump, very few women under President Trump. There's a lot of work to do to make sure that people who are public defenders are represented on our courts, who have all types of different backgrounds and experiences, so that the federal courts start to look and feel more accessible.
Thanks, Eric. I'll turn to another question now. There's a question about, is there much of a chance that, Patrick, all of these bills that you were speaking about that have been passed at the state level that have changed how judges are chosen or what courts can do, what is the likelihood that that at least some of these may be overturned in litigation at either the federal or state level?
Sure. So it depends on what the state's constitution says, but there have been instances where a state Supreme Court has struck down a bill that changed the way judges were selected. A state that immediately comes to mind is Montana. The legislature back in 2011 put a similar measure that would move from statewide elections to districted elections, along with what's going on in Pennsylvania. And that was struck down in court there because it required justices to reside in the district from where they were chosen. And there have also been other instances in Montana as well, which has been a hot spot, unfortunately. The legislature passed a law getting rid of the Judicial Nominating Commission, instead allowing the governor to make direct appointments when there's a vacancy on the Supreme Court and district courts. And a lawsuit was filed immediately the next day, and that's currently pending in the courts right now. So we'll see.
That's a good example. It makes me think of a lawsuit the Brennan Center was actually involved in several years ago in Kansas, where we challenged, representing a judge in Kansas, a law that had weakened some of the court's budgetary and administrative powers. And then the state legislature passed another law that tied the funding for the entire judiciary of Kansas to the outcome of our lawsuit. So like a very stark example of threats to judicial independence that thankfully they eventually, there was sort of so much public outcry, they backed down, and we didn't end up having to sue over that one as well. I guess the next question I'll pose, maybe first specifically to Katie, and then if others have things to add as well, about kind of what is the rationale for the assaults on judicial independence that we're seeing? Kind of what is ultimately motivating the targeting of the courts?
Yeah, so we talked a little bit about it. There's certainly an underlining motivation that legislators aren't happy with the decisions that are coming out of our state Supreme Court, right? Because of our state mandated closures of COVID, on our voter fraud and elections issues, legislators want to hold judges accountable. But what we're also seeing on from the Republican legislator who proposed this constitutional amendment, Representative Russ Diamond, is he claims that this is going to solve a problem of geographic diversity on our appellate courts, when really there really is no problem. He's proposing this to solve a non-problem. We have actually judges that come from all across our state, some even from out of state. There's actually one judge who is from Germany. So when you look at actually where our judges come from, they are coming from all across our state. You know, Philly and Allegheny County often get thrown out because many of our judges, you know, come from there. But when you actually look at the percentages and the numbers, they get called out for too many judges, right? But actually 22% of our entire population of Pennsylvania comes from Philadelphia and Allegheny County, and 30% of judges comes from those areas. So that's pretty good representation. If you do get a chance to watch our little explainer video, as I plugged before, it actually shows you a couple of our judges and where they come from, and you'll see it is actually all across the state. So a couple different things going on as to, you know, what the motivation is there, but that gives you a little bit of picture.
Thank you. Thank you so much. I think I'm going to, we're almost at time. I'm going to use moderator's prerogative and throw out the last question, which is, I'm going to throw it out to each of our wonderful panelists. I'd love a call to action. We've had this really interesting discussion about some of the threats to fair, impartial, and diverse courts. As people click off Zoom today, what should they do? So I'm going to turn to each of you in turn. Eric.
I'm so used to talking to lawyers about what they can do, and that seems to be pretty easy, right? Because we can bring lawsuits, we can run for judge, we can get appointed. But you know, for regular people, I would just encourage folks to really start looking at some of the issues that we're talking about right here about attacks on judicial independence across the country, because you know, it might not be happening right here in New York to the level that it is in other states, but in other states, some of the outright power grabs that are happening when it comes to adding seats to the Supreme Court, directly threatening Supreme Court justices, tying them to particular decisions. I would say, you know, you have to start thinking about those high court battles, appellate court battles, as you do any other political process, and become just as involved and engaged. Because many of the, you know, racist attacks that we see come against judges for not being tough on crime, and it has a real effect on the way that judges decide cases. So the way judges are picked, the types of judges who are serving, the attacks on judicial independence across the country are really an issue for all of us, no matter where we live.
Thanks, Eric. I'll turn to Patrick next.
Sure. So I certainly agree with what Eric said. And, you know, I would again just emphasize that it's incredibly important to pay attention to courts. I think often people don't think about courts unless they're interacting with them. And so they fail to recognize just how much influence they can have over our day-to-day. And so I think it's very important for people to understand what courts do and what's appropriate for courts to do and what isn't appropriate for courts to do. And so I would encourage everyone just to do a little civic education and learn more about the courts, and share that knowledge with your friends and loved ones.
Thank you, Patrick. And Katie, I'll turn it to you.
They took everything I was going to say. No, but completely agree. I mean, what we've seen in Pennsylvania is people are starving for information on what our courts do on the judiciary system. Every time we've done a town hall, an educational event, and we've gone into, this is what our state courts look like. This is who are our judges. This is what happens. This is what kind of cases our judges hear. We've gotten so much praise. So, I mean, just to continue to educate yourself and others on our judiciary, and then also support, local organizations. So I know I talked about a couple organizations before, Why Courts Matter Pennsylvania, one of the organizations that I'm a part of, as well as Common Cause Pennsylvania and Pennsylvanians for Modern Courts. Both of those organizations are a part of our Judicial Independence Project of Pennsylvania Fight Back table, and do incredible work on the ground in educating constituents, people of Pennsylvania, on the courts. So it's really important to, try to search for organizations that do this work, that reach out to local communities, that hold these town halls, these educational seminars, because that's how this information is getting out there.
Thank you. Thank you so much. And I think we're reaching the end. So I'm just going to close us out with some additional thanks. A huge thank you to the Center for Brooklyn History, the National Association of Women Judges, and the American College of Trial Lawyers, as well as to all of our panelists here, as well as in the earlier presentation, and all of you for joining us for this important conversation. Thanks so much.